name is Lee White, and I'm one of the family law attorneys here with Jodat Law Group. I'm going to be talking with you today about support, specifically financial support. So in Florida, we have two different forms of financial support. We have spousal support, which is commonly referred to as alimony. And then for cases involving children, we also have child support. So both forms of support deal with payment from one party to another, but they're actually calculated very differently. So with alimony, support from one spouse to another, it does not have a specific calculation. There is no specific formula. There is no entitlement to alimony in the state of Florida. It is not an automatic right. But it is a legal remedy that can be pursued depending on certain factors. When we're dealing with an alimony case, we look first at the duration of a marriage. Florida law defines a short-term marriage as anything under 7 years. A moderate-term marriage is anything 7 years but less than 17 years. And then a long-term marriage, which is anything 17 years or more. The duration is important because it defines typically the types of alimony that are available. There are many different forms of alimony. You can request temporary alimony, which is spousal support during the pendency of a divorce case. There are different types of durational alimony, referred to as bridge the gap, rehabilitative alimony, and durational alimony. And although they are defined slightly differently, the concept is that it is support payments for a defined period of time. So permanent periodic alimony is typically only available in long-term marriages, but that's not always the case. When we're dealing with any alimony case, we're really looking at two primary concepts: a spouse's financial need for alimony and the payor's ability to pay. When we're looking at need and ability to pay, we're looking at both spouses' earnings or ability to earn and their reasonable and necessary expenses. So either spouse can request alimony. They have to be able to prove both of those key concepts, that they have a financial need and that the other party has an ability to pay. If they can't prove both of those prongs, they lose their alimony claim. So when we're defending against an alimony case, we invest a lot of time scrutinizing the requesting party's income and scrutinizing the expenses that they're claiming. And we do that to reduce as much as possible their claim for a financial need. We also invest a lot of time with our clients making sure that they're receiving credit for every reasonable expense that they're paying and that their income is calculated properly. We do the opposite when we're pursuing an alimony claim for our clients. We want to make sure that their expenses are accurately calculated. We also want to make sure that the opposing party is going to provide the financial assistance that our client needs. Child support is different. So child support has a specific formula. Child support is treated as a right of the child, so it is automatic. The actual amount that would be paid and who's paying it is what's actually up in the air. We look at their income that they're actually earning or their ability to earn income. Child support actually doesn't take into consideration very many expenses, whereas alimony does. Alimony is very expense driven. With child support, there's really only a few key relevant expenses. Those being the cost of private health insurance for the parent and the cost of insurance for the child, the cost of child care, and one of the bigger factors is also the type of parenting plan that is implemented, and Attorney Newton-John's going to be talking about that in just a little bit. So with child support, it is much more of an automatic thing. It is a matter of determining the incomes and applying the state-mandated formula. The biggest difference really between the child support and the alimony, aside from the way that it's calculated, is the potential tax consequences. So with alimony, that can be tax deductible to the payor and taxable against the recipient as income. But that's not the case with child support. Child support is something that we treat really as being tax neutral. With both alimony and child support, you can request retroactive support. You can request retroactive alimony to cover the period of time from when the parties separated up until the date that there's a final determination of the alimony claim. The same is true for child support. So we can establish both ongoing support in terms of spousal support and child support, as well as establishing an unpaid balance for support that was owed during the time of separation.
What can you do to defend against an alimony claim from someone who isn't working?
If we have an opposing party who is not presently working, we can make a legal argument that they should be imputed to income. And what that means is, even though they might have an actual earning capacity of zero, their actual earnings are zero, we can make an argument that the court should treat it as though they are earning money, even though they aren't. So with alimony cases as well as with child support cases, a common imputation is to use minimum wage income. If a person is physically and mentally capable of working, it's an easy argument to make that they at least have the ability to earn minimum wage. If you're looking to impute income beyond minimum wage, it's a little bit more involved. We typically get a vocational expert to do an assessment of the requesting party to determine, based on that expert's opinion, whether they have an ability to earn more than what they're claiming to earn. Any other questions?
What happens if you are paying alimony or ordered to pay alimony and then you lose your job? How do you pay it?
You need to file a supplemental petition to modify. And it's very important that you do that, because if you wait, you can still be subjected to enforcement action for your non-payment of the support obligation. So it's important to file that supplemental petition to have the alimony either temporarily abated, permanently abated, or minimum reduced so that it is consistent with what your current ability to pay is.
I have a question. Can someone who files bankruptcy get rid of their child support, or their alimony orders?
No. Both alimony arrearages and child support arrearages are non-dischargeable in bankruptcy. That debt sticks with the payor indefinitely until it is paid.
Thank you.
Okay. Thank you.